Okay, hello everybody. I'm Melissa Steinman. I'm a partner in Venable in DC. And while I sit primarily in our advertising law group, today we have something a little bit different for you, and we're going to talk about the Consumer Product Safety Commission. A lot of our ad law clients come to us, and certainly many of the clients in the firm come to us with issues like I've got a new product, or I'm thinking about selling a new product. What kinds of issues do I need to worry about when it comes to consumer product regulation, safety regulation, or I think I may need to recall this product. We've been getting a lot of complaints that are safety complaints. I've been injured, or this caught fire. That's that type of complaint. And so these are all issues that come within the purview of the Consumer Product Safety Commission. So today I'm joined by Chicago partner Erin Mouse and Alex Rubel, who's in our DC office, to talk about the Consumer Product Safety Commission and really not only what it does, but what's happened this year, which has been a very eventful year at the Consumer Product Safety Commission, like so many of our regulatory agencies, with the change of administration. So welcome. I'm glad you're here, and let's get going. There's lots to talk about. Okay. Where are we now? 2025 was a year of extreme change, really, for all of us. But when it comes to the CPSC, much has stayed the same. The political and leadership dynamics have really shifted a lot. But regardless, there is still broad political consensus when it comes to issues like child safety, what to do with regard to online platforms and how we can keep people safe when shopping on those platforms, batteries, furniture safety, and many other regulatory priorities. So overall, of course, the mission of the CPSC, regardless of which party has control of politics or a policy, is to protect against the unreasonable risk of injury from consumer products. Nonetheless, there's been important functional changes and changes in focus. Most importantly, perhaps, there are no Democrats left anymore on the commission itself. We'll talk about that in a minute, but the Democrat commissioners have been fired. That issue is going to come up on Monday, whether there was the power on the part of the president to do that. But there's the question of whether there is a legal quorum there. Certainly, there's a very tenuous one. There is this increased focus on e-commerce and marketplace enforcement, how to keep e-commerce safe for consumers, a focus on imports and certain high hazard categories, which we'll discuss, and a very aggressive stance with regard to recall demands and the use of unilateral press releases by the CPSC with companies that will not respond to recall demands the way that the CPSC wants them to. There also continues to be a very aggressive stance when it comes to civil penalties for late reporting. This was something is not new, but it continues to be the case. And what is new or developing, at least, if not new, is the use of very, very sophisticated data analytics, increased use of things like AI to sort the data that they're getting, and then collaboration with other agencies, as well as internationally, when it comes to recalls and sorting through data. So we're also looking ahead. There'll be continued increased use of things like AI, smart oversight, data, We'll also be talking, in addition to talking about all these developments today, about some practical steps that you can take when it comes to um, both following these developments and then, more importantly, what you can integrate into your compliance program to make sure you're staying ahead of things. So let's go. Um, Perhaps the most interesting things that we've all been watching in DC and across the country right now have been some of the developments when it comes to the agencies and who's in charge at the top, as well as the pushing out of anybody who's a Democrat when it comes to leadership. With independent agencies like the CPSC or the Federal Trade Commission, the NLRB, the Trump administration has pretty much purged the government of Democrats. So in normal times, the Consumer Product Safety Commission has 5 commissioners, no more of than three of whom may be nominated by the president from the same political party, and commissioners may not be removed without cause. The Trump administration, however, had none of this. And in May, they removed all 3 Democrat CPSC commissioners, Boyle, Commissioner Hohen Sarek, and Commissioner Trumpkin, and Commissioner Mary Boyle, to say it more respectfully, shall we say, without cause, leaving just acting chairman Peter Feldman, a Republican, and Commissioner Douglas Ziak. Forgive me if I just mispronounce that, but also a Republican. The 3 removed commissioners sued. They were granted reinstatement by the federal courts. Um, Initially, the Supreme Court granted a stay against the Democratic commissioners' reinstatement. Um, uh, and so now that case will be heard in full. Oral argument will be heard on Monday. So this is going to be particularly interesting in that it's part of a sort of constellation of cases that looks at whether a case called Humphrey's Executor, which Alex will talk about it on the next slide, should be overturned or not. There's a lot of speculation as to whether it will be, and we should find out, this year, this term. But what we've been left with in terms of the actual dynamics of the commission is that after Commissioner Ziak was retired, Feldman is now the sole remaining commissioner. The quorum expired in November after 6 months. But what happened was Feldman, I'm sorry, before the last other remaining commissioner resigned, he and Feldman had delegated the CPSC authority to acting chairman, rather, Feldman, which may have removed the need for a quorum. We'll see. But for now, basically, acting chairman Feldman is the last man standing, operating on his own, or was until in October, President Trump nominated William Billy Hughes III, who's also a Republican. Once he is confirmed, this will restore the quorum, which only needs to be 2 commissioners, for 6 months, unless a third commissioner is confirmed. So if you're confused, I don't blame you. The rules of quorum are complicated, but let's just say that it'll all be a lot calmer on sort of the Byzantine rules of how these independent agencies work and what is a quorum and who can be a commissioner or not. Once we have a decision on the Humphreys Executor case. But for now, we're all operating in rather novel territory when it comes to this sort of thing. And independent agencies like CPSC, FTC, same fight going on, NLRB, all of these. So why don't you talk a little bit more about Humphreys Executor, Alex?
Thanks, Melissa. So quick history lesson. Uh, President Hoover reappointed William Humphrey as FTC commissioner. Uh, President Roosevelt was worried that William Humphrey would not go along with his New Deal agenda or not be sufficiently supportive, and so asked Humphrey to resign from his post as FTC commissioner. He asked several times for him to resign. Humphrey said no, uh, and FDR then fired him. Um, Backdrop again. This happened against the backdrop of federal law, which said that the FTC commissioner could only be fired for cause. And so Humphrey sued, um, or more specifically, his estate sued because Humphrey had passed away, um, and sought unpaid wages. The Supreme Court held that essentially they upheld the law as constitutional. Uh, the president does not have the right to fire uh, heads of so-called independent agencies without cause, the Supreme Court held. Um, and the analysis they did focused on the type of power that was being wielded by the FTC. The Supreme Court held that because the FTC was not exercising pure executive power, but rather quasi judicial and quasi legislative power, um, it would not fall within the scope of the officials that the president is allowed to fire without cause if Congress puts in place federal law that prohibits the president from doing so, as they did here. Um, the reason why this is important is because it's allowed independent agencies to thrive and be insulated from partisan politics to an extent that perhaps they would not be if commissioners could be fired for cause, fired without cause, rather. In Trump v. Boyle, this was a case of the FTC of the CPSC commissioners suing to be reinstated for they were fired without cause. The Supreme Court has not yet ruled on the merits, but they indicated that they were likely to, at least reasonably likely, to overturn Humphrey's executor when the merits reached them. They said the stay we issued in Wilcox was a similar case involving the NLRB, reflected our judgment that the government faces greater risk of harm from an order allowing a removed officer to continue exercising the executive power than a wrongfully removed officer faces from being unable to perform her statutory duty. When an emergency application turns on whether this court will narrow or overrule a precedent, there's at least a fair prospect, not certainty, but at least some reasonable prospect that we'll do so if we grant a stay, but do not also grant cert before judgment. We may leave the lower courts and affected parties with extended uncertainty and confusion about the status of the precedent in question. The liberal justices dissented, but I think the writing is on the wall that Humphrey's executor is going to be overturned, or at least narrowed and distinguished to a point where it does not apply to NLRB and CPSC. In addition to the uncertainty surrounding who is the rightful commissioner of CPSC. In April, a draft OMB document leaked that contemplated eliminating CPSC altogether and transferring its responsibilities within HHS. This sounds crazy on its face, but actually would not be unprecedented. Uh, the year before CPSC was created, I think in 1973. So in 1972, a bill was introduced to the House that would have established a unit within what would later become HHS. to serve CPSC's functions. So this was contemplated at one point, the year before CPSC was created, and ultimately Congress went in a different direction. But now it seems that there's some interest in revisiting that approach. Um, CPSC's budget request uh, requested that CPSC be reorganized within HHS and for its funding to be cut by about 10%. Um, it's unclear how likely this is to occur, even though it's what CPSC has now requested and what OMB was contemplating. But even if it does happen, the new CPSC would have about 90% of his budget and would still be enforcing the same laws. And the 10% reduction in budget may be offset, at least to some extent, by administrative efficiencies that come with access to HHS infrastructure. So they may be just as capable of enforcing those laws as they would otherwise be. But in any event, the fact that President Trump has nominated a new commissioner suggests that perhaps it's not so likely to happen. Because if it was to happen, there would be no need for multiple commissioners. There'd be no commissioners. You certainly wouldn't need two.
So I'm going to pick up here and talk a little bit about what has actually happened at the CPSC in 2025, despite all of these changes and uncertainty and all of what Alex and Melissa have just walked us through. Because it begged the question, if you have such significant changes, particularly at the leadership level, did that mean that the CPSC either changed its focus or was unable to act efficiently and effectively? And the answer really is no to that, that the CPSC really continued to move forward and manage its mission quite effectively. It doesn't mean those changes didn't have some impact, and I'll sort of talk through what those impacts are. But the reality is the CPSC was very active. It really was the year of the recall. In September, acting chairman Feldman announced that the CPSC surpassed the 2024 number of recalls and product safety recalls and warnings, more than 3 months, obviously, before the end of the year. Recalls have continued to roll out quite significantly since September. Acting Chairman Feldman described this surge as reflecting a stronger, faster, and more vigilant CPSC. And importantly, because I think this really is a significant shift at the CPSC, he stated that the increased number of recalls reflects the CPSC's resolve to fight and confront foreign manufacturers of products. He has long talked about the surge of foreign products coming into the United States, particularly through e-commerce, in a way that is not compliant with mandatory safety standards or voluntary safety standards and present significant safety risks. And so from his perspective, the increased number of recalls is a reflection of the CPSC's focus on products that are coming from that are foreign manufactured and brought into the United States. He also stressed that the CPSC has an increased focus at the ports and the borders, and that increased focus has resulted in the higher number of product recalls this year. He noted that they've screened over 750,000 individual units at the border. That really is a significant increase compared to years past. You can imagine how many products come into the United States every single day. The ability to screen those products is challenging, but the CPSC has really made that an increased focus. We'll talk a little bit later about how they're using AI and their e-filing changes in an effort to really increase their border security, their import security. He also referenced that that the increased number of recalls is also tied to the number of unilateral press releases that have come out. That is a significant change. We've been monitoring this for the past couple of years when the CPSC started as an enforcement mechanism to utilize what they describe as a unilateral press release to inform the public about a product safety or non-compliance issue that they deem significant. The use of unilateral press releases in the last 2 years is equal to the amount of UPIs that were issued in 2025 alone. It really is a focus. Those UPIs are focused on foreign products, foreign manufactured products. They are used most typically when foreign manufacturers or importers are non-responsive to the CPSC or refuse to take action that the CPSC deems necessary to protect the public. The CPSC has used the threat of unilateral press releases in more sort of traditional enforcement discussions with, let's say, US companies, for example, but really the 91 unilateral press releases are in large measure focused on foreign produced products and foreign manufacturers that have no presence in the United States, are utilizing e-commerce to bring their products into the United States, and are not acting cooperatively with the CPSC. Next slide, Alex. Another significant change at the CPSC in 2025 was that a significant amount of rulemaking was withdrawn. The CPSC's legislatively mandated mission is obviously to reduce the unreasonable risk of injuries associated with consumer products, and it typically does that through two ways. Recalling products that are defective and present a substantial product hazard is one primary way, but the other way is to issue and enforce mandatory safety standards. You may recall that shortly after taking office, President Trump issued an executive order that imposed a regulatory freeze, essentially wanted all new regulations, if any independent agency was going to engage in rulemaking, to flow that whole process through essentially the White House. Following the removal of the Democrat commissioners, as Melissa explained, the two Republican commissioners took some steps to withdraw rulemaking that was already active prior to Trump taking office, that was active at the CPSC. The first thing they did was addressing gas stove emissions. That was a sort of hot button issue for Republicans, and the CPSC had gone down the path of regulating those emissions. That rulemaking was withdrawn. The CPSC also withdrew what was an ongoing lithium-ion battery rulemaking process. We'll talk about that process being reinvigorated, which it in fact has, but they immediately withdrew that active rulemaking shortly after the two remaining Republican commissioners were allowed to act. They continued down this deregulation path, and in August, Acting Chairman Feldman announced that the CPSC was withdrawing additional and pending rulemakings that he described as no longer being aligned with agency priorities. He also indicated that these pending rulemakings failed to advance safety. Those that were withdrawn are on this slide here. Some relate to specific products, others relate to sort of regulatory, like the 6B issues, the information disclosure under Section 6B, that relates to how the CPSC communicates certain information to the public. So there were a wide variety of regulations that were, again, pending in the process that Acting Chairman Feldman has withdrawn. He explained further that this move signals a fundamental shift under CPSC's new leadership, which is his leadership, to focus on what he described as sound science, robust data, and common sense. He further stated that going forward, the Commission will act where mandatory standards are truly necessary, and the evidence shows that federal intervention will meaningfully advance safety. Regulations that promote unscientific agendas, impose unnecessary costs, and reduce competition are no longer agency priorities. And so these standards that you see here are presumably don't do those things, at least from his perspective, and so they have been withdrawn. The next slide, Alex. But despite all of what I've just said, that CPSC has withdrawn some rules, and despite withdrawing the rules detailed on the previous slide, the CPSC has advanced toward finalizing a few mandatory product safety rules. Acting Chairman Feldman described these standards as critical safety standards. And he stressed that these safety standards were critical from his perspective because these types of products tend to be products that are manufactured in China. So again, publicly underscoring the CPSC's focus on products that are manufactured in China, although they are not exclusively manufactured there. That became, from his perspective, an important reason for advancing these particular safety standards. They include rules related to water beads, to neck floats, and here's where the lithium-ion batteries come back in, lithium-ion batteries that are used in what are known as micro-mobility products. So the water beads mandatory safety standard are there to present choking and ingestion hazards to young children. Once swallowed, water beads can really create some significant internal injuries, and in some cases, there have been reported deaths associated with water beads. Again, the CPSC really focused on the fact that a substantial share, as they described it, of water beads sold in the US are manufactured in China and distributed through online platforms with little to no safety warnings or vetting, which typically means some sort of testing. So the rule sets a variety of performance standards and requires warning labels. The next standard are neck floats. The Commission is finalizing this safety standard for neck floats. This really comes from the CPSIA, a directive in the CPSIA in 2008. So this has been in the works for quite some time. The CPSC, through Acting Chairman Feldman, noted that these products have been linked to multiple drowning deaths and serious near-fatal incidents. He also noted that many of these neck floats sold in the US are manufactured in China, again, come in through e-commerce platforms with little to no safety oversight. And the rule, as you see here, establishes performance standards and also requires warnings so that parents can understand the risks. Essentially, where what neck floats can and cannot do in terms of ensuring swimming safety. I'm sorry, one more point, Alex. The CPSC also noted that drowning is a leading cause of death for children between the ages of 1 and 4. Melissa noted in her initial comments that the CPSC is focusing on the highest level of risks, and certainly products that that parents may assume have safety features but really don't have those features, and that those products are aimed at vulnerable children, particularly infants, as neck floats do. Those are going to remain a significant priority for the CPSC. All right, Alex, next slide. So now back to lithium-ion batteries. There's been a number of stops and starts with respect to regulating lithium-ion batteries. Again, the CPSC, once the Democrat commissioners were fired, the 2 remaining commissioners at the time withdrew the rulemaking that was in progress. The House itself passed its own act in April 2025 that would require the CPSC to adopt some industry standards related to micromobility, the use of lithium-ion batteries in micromobility products. The Democrat commissioners, if you recall from Melissa's description of the process, they got fired, they were reinstated, then the Supreme Court allowed their firings to stand, overturned the injunction that kept them in their jobs. The Democratic commissioners had reintroduced the rulemaking that the Republican commissioners had withdrawn. That has since been removed again, and ultimately the CPSC, through acting chairman Feldman, has introduced its own and new standard to the appropriate agency that President Trump has designated as reviewing all rulemaking authority. And that's where it sits today. So the Office of Information and Regulatory Affairs is reviewing that particular regulation. Presumably, if they give approval for that regulation to move forward, the CPSC, through acting chairman Feldman, will begin the rulemaking process, which is lengthy, time-consuming, requires public comment and all of that. So this is not something that's going to be resolved quickly. But if you are importing, distributing, selling products in the micromobility sector, e-bikes, electric scooters, this is the safety of lithium-ion batteries is in fact a priority for the CPSC. And I fully expect that some mandatory standard will not only be introduced, but eventually be passed. When that is, I don't know, but it is something to really keep your eyes on. Okay, next slide. So I want to talk very quickly about Reese's Law. This is not a new development. Reese's Law has been enforced for a couple of years now. The law itself applies to button cell or coin batteries that are found in a wide variety of consumer products, both children's products and toys, and adult general use products. The law itself imposes a variety of performance and labeling requirements, all of which are really aimed at preventing children from gaining access to the button cell or the coin battery. Ingestion of those batteries can lead to significant health issues. The CPSC exercised some enforcement discretion and did not begin enforcement or actively enforce Reese's Law until various points in 2024, depending on which part of the law was at issue. But what we have seen in 2025 is that enforcement is increasing. And it's increasing with a wide variety of products. Not just children's products, but also general use products, or those products that are typically used by adults. The risk of children gaining access to button cell batteries, even if they are not using the products, is seen as a significant risk. Just a note about sort of recalls and the CPSC's authority. Recalls are most often tied to defective products and a finding that those products present a substantial product hazard. However, the CPSC also mandates and has the legal authority to mandate a recall or a corrective action related to a non-compliance with a mandatory standard, and that or a law that it enforces, which is in fact what Reese's Law is. And because the CPSC enforces it, non-compliance it triggers a reporting obligation to the CPSC, and it also triggers a potential corrective action, including a product recall. So we're seeing that on the rise. I don't expect that to change. And so brands that are importing, distributing, or selling products that contain button cell batteries should review those batteries in compliance with Reese's Law to avoid that enforcement impact. Okay, next slide. E-filing, this isn't quite a 2025 issue, but in 2025, CPSC has really been pushing for consumer product companies that are responsible for importing products. So if you're an importer of record, it's really been pushing importers of record to get prepared for e-filing. And e-filing is essentially a CPSC initiative that requires importers of regulated consumer products, so any consumer product for which there is a mandatory standard, that they file certain data elements that are typically found in your certificates of compliance. You're obligated to file that electronically with U.S. Customs and Border Protection via what's known as a PGA message set. So, importers understand what these electronic requirements are, but e-filing is now mandatory, or it will be mandatory. It goes into effect July of 2026. So 2025 has really been the CPSC pushing for companies to get ready. And import surveillance is obviously, as I've mentioned before, a top priority. It's going to remain a top priority for the CPSC in 2026. And so e-filing is a way for the CPSC to do that more effectively. Any company that has imported a product that is that requires a certificate that is subject to a mandatory standard is understands that you have to have a certificate of conformity to that essentially confirms that the product has been tested and certified to that safety standard. Any children's product requires a children's product certificate. What e-filing does is take all the information that you already have to collect and requires it to be uploaded electronically, as opposed to just being a physical document that you all might keep in your records and make available to the CPSC or CPB if that was required. But now it's all going to be electronically available to the CPSC and CBP, which will enable the CPSC really to improve its risk assessment methodology at the border. It should, in theory, lead to port inspectors being able to more effectively identify the products that have the greatest hazard risk and inspect those products and conduct the import surveillance that the CPSC wants to conduct, and to do it more effectively. Whether that actually will prove true in practice is yet to be seen, obviously, and e-filing is very complicated and does require a lot of preparation and, in many cases, sort of internal software updates and real practical changes in how you manage the importation of products. So if you are an importer of record, this is something that you really need to keep on your radar.
Okay, let's say the CLE code for a minute, which is CPSC 2025. That's CPSC 2025. And then we'll talk about e-commerce platforms. E-commerce platforms, as we mentioned earlier, are really in the hot seat right now. They've been designated as a top priority. The CPSC 2025 operating plan sort of formally says that that is a top priority. This is in large part due to persistent issues with unsafe products being relisted after warnings, especially from overseas sellers of the type that, from China or from other countries. And then, there are challenges with identifying the responsible party. Importers, of course, have responsibility to report. So that's there, but nonetheless, what has resulted here are things like more port seizures and online surveillance, these joint international actions with regulators in the EU, the UK, coordination between customs and state attorneys general, and then in addition to where the traditional responsibility does rest with importers and foreign sellers. There's been this focus on the seller, the direct to consumer platforms, and the marketplaces has been sort of ratcheted up here to try to make sure that these unsafe products are pulled off the marketplace. The greatest concern has been about unsafe children's products, fire and chemical hazards, and any place, of course, where there may be vulnerable consumers. But there are certain places where the CPSC has had a particular focus. Additionally, these counterfeits and lookalikes are tend to be an area where there's particular focus, as well as I mentioned earlier, where there's a product that maybe has been delisted and then shows up under a new listing or a new name. The CPSC tends to take a special interest in that sort of product or conduct, frankly. This is the situation where online channels are no longer just another distribution channel, but an area of particular interest. And so it's something where if you're a manufacturer or a seller, you need to be aware of this and take, note. You need to know everywhere that your products are showing up and make sure that that's under control. Whether you're selling as a first party, whether you've got resellers who are selling there, whether there are third parties who are selling on an unauthorized basis in the gray market. You need to be tracking to have visibility into where your products are showing up online and have a strategy for monitoring and seeking takedown. It's not enough to just say, well, I don't control that. If you know that these products are showing up on marketplaces, you need to take account of that. Whether it's focusing on contractual controls and audit rights for online sellers, using recall and takedown procedures that the platforms have developed to try to get unsafe products, or infringing products for that matter. Intellectual property can be a good way to get a product that you're worried is unsafe offline. Keep monitoring for counterfeits or gray marketing to avoid misuse scenarios. And also, you should be coordinating with marketing, looking for claims or imagery or user generated content that can create misuse scenarios that the CPSC may ultimately point to, whether it's the way a product is shown or described that can encourage uses of a product that were never considered when you were initially making your use assessment, your risk assessment. The CPSC will certainly cite that when evaluating the foreseeability of misuse of a product. And so you want to make sure that your legal, your safety, and your e-commerce teams are aligning to prepare you to try to foresee when something may go wrong or is going wrong, from a product safety perspective. And make sure that you're protected. So, there's this sort of um, multi-pronged strategy of mapping where your products are going, monitoring the marketplace for counterfeits, unauthorized sellers, implementing contractual controls, and then looking at your marketing and what you're doing there to make sure you are not exposed there. On the next slide, there's what happens if something does go wrong. There is this issue of the CPSC continues to pursue these very large penalties. So, it's once you do find something that's going wrong, once you, think there may be an issue out there, you need to look at whether you need to report, because the penalty for late reporting or repeat violations is very large. These have been ranging in the multi-millions of dollars. We'll talk about a few specific penalties in a minute, but it's just in double or even sometimes triple digits for late reporting. And when we say late reporting, it's not just a matter of, oh, well, it's a new issue that wasn't reported, but sometimes even a situation where, you reported things were closed out of an excess of caution, the matter was closed, no need to report, and then you keep getting, reports of injuries or the like. And gee, do we need to report again? That there have been situations where, yes, if you keep getting complaints of injuries over a period of time, even where there was an initial determination that there was, no need to make a recall, that could later trigger a need to, file again, or at least, any closing like that. The CPSC generally says, nope, if you keep getting complaints, please let us know because later on they could reopen things. And the CPSC has, in some cases, upon getting reports of further complaints from either the seller or retailers or third parties, reopened cases. And in that case, they could seek late filing penalties as well. So red flags for brands for possible, late reporting penalties down the line. Situations where there's a long lag between the first incident and internal escalation, fragmented incident data between business units and or countries, where it's not sort of collected together. One hand doesn't know what the other one is doing. Treating foreign incidents is less relevant to U.S. risk. The CPSC does expect you to take into account the fact that there have been incidents in other countries at this point as relevant to your decision to report. And like I said, failure to report continued incidents after a report closure. We were still investigating is not an excuse. While you do have a reasonable amount of time to investigate and decide whether an incident is reportable, but that time period must be reasonable under the circumstances. It's not forever. It's it's a reasonable amount of time, which generally is, certainly not a matter of months, years, etc. So you need a process for collecting complaints that are coming in, centralizing that, and centralizing the decision whether to report. And then the fact that you have a process and you can show that to the CPSC if there ever is, God forbid, a late reporting investigation, is going to, definitely help you with the CPSC, the fact that you can point to that, as with other agencies as well. Um, so you should be come up with a compliance plan, train your business teams on what to flag, centralize your incident data, and then document your decision making process so that you can ultimately, if necessary, show that decision making process was reasonable and that you acted promptly. If everyone in your email chain is nervous about how this may look in hindsight, that's your tip off that you should be talking to the CPSC sooner rather than later. Talking about specific situations where there were late reporting cases, I'm going to turn that over to Erin.
Yeah, we're just going to take a couple minutes to talk about two instances of enforcement action at the CPSC, both of which occurred in 2025 and were remarkable. Remarkable in the sense that they don't happen very often, one of which is happening for the first time, and it all relates to the CPSC's enforcement authority to seek criminal penalties. So the Consumer Product Safety Act, and as amended, has allowed for the CPSC to seek criminal penalties against corporations and individual actors at corporations. The CPSC has not availed itself of that enforcement right and mechanism for quite some time. But in 2025, we saw 2 instances where they did, obviously through the DOJ. The first related to Royal Sovereign International. This is a late reporting penalty. And you can see that there's a civil penalty that, as Melissa has been describing, the ability to seek a monetary penalty for late reporting has long been an enforcement activity of the CPSC, and they did that here. But they also sought criminal penalties against the corporation for essentially a conspiracy to not inform timely the CPSC of product safety issues. And as a result of that, they received a corporate plea agreement where the company admitted that it willfully misled the CPSC in terms of, well, first of all, that it willfully failed to timely report, and also that it willfully misled the CPSC. Once it did report, it only reported 2 incidents as opposed to I think there were more than 15 incidents involving their product where there were significant fires and property damage. And the CPSC was able to utilize that and its enforcement mechanism in conjunction with the DOJ to seek what they ultimately received as a corporate plea agreement. In the next instance, Alex, next slide, they actually got some prison time for 2 officers and directors of a company, a foreign company, although it has a U.S. entity here, Agree USA Inc. 2 executives were criminally charged and ultimately were sentenced to 28 and 40 months in prison for failing to report timely to the CPSC what were hundreds of incidents involving their products. Gree supplied a number of name brand companies. They were the contract manufacturer for a number of name brand companies. Those companies ultimately took action to recall the products under their own brands. But at the end of the day, the manufacturer was aware of what were hundreds of significant fires and millions of dollars in property damage and didn't disclose that to the CPSC. This was the first time that the CPSC through the DOJ sought criminal penalties that resulted in prison time against individuals, and obviously was able to obtain that. These are significant and egregious examples of failure to report timely and failure to report robustly to the CPSC. But they are notable developments. Acting Chairman Feldman noted for both of these instances that the CPSC is willing to use every single enforcement right that they have, including to seek criminal penalties. And so, it is the type of thing that companies really should be worried about. And as develop your policies and procedures about how you manage and analyze incidents, as Melissa's just described. Ensure that you have a developed program that allows you to take into account and analyze your reporting obligations quickly, timely, and through the right people. I often like to say that your policies need to ensure that the right information gets to the right people quickly, so that decisions about reporting and acting can be made by the people that are ultimately responsible. Because those people, like here in Gree, could find themselves exposed to these kinds of penalties. Again, for egregious circumstances, but still noteworthy. Next slide. So we're nearing the end of our time. We want to talk just quickly about some of our predictions for 2026. I've alluded to a few of those, but we don't expect that the number of recalls and unilateral press releases is going to decrease. In fact, I think it will increase significantly. We also think that companies that are voluntarily working with the CPSC, so those that voluntarily report and are working cooperatively with the CPSC, will will gain some flexibility in how, how all of what happens is unfolding. It doesn't mean that the CPSC isn't going to say that a recall isn't required or that some corrective action isn't required. But we do think that there's going to be a level of cooperation with those companies, because that's a good thing, right? The CPSC wants companies to be coming to them voluntarily, and they really are focused on the bad actors, and again, sort of behooving companies to have the right programs and policies in place so that you can demonstrate your cooperation with the CPSC if you ever find yourself working with them. We don't think there's going to be significant new substantive rulemaking from the CPSC. Obviously, lithium-ion batteries, as I've noted before, is going to continue that process, assuming it gets approved by the Trump administration. I do think that process will continue in 2026. But in terms of a number of new rules coming out, we don't expect that to happen. The CPSC does have the mandate to work with the likes of UL and ASTM, other voluntary standards bodies that create safety standards that are voluntarily followed by product manufacturers. We do think the CPSC will continue to work alongside and cooperatively with those bodies to develop voluntary standards. But in terms of mandatory safety standards and rulemakings, we're not seeing much coming down the pike. I mentioned e-filing before. It's coming. It will be painful. There have been, companies that, and rightly so, people asking, do we think in light of all the changes at the CPSC that e-filing might be tabled? And I'm not sure that's the case. I think it's probably still coming. We had a question about who's responsible. E-filing doesn't change any legal obligations. Every company that produces a product that is subject to a safety standard right now, today, has to have a general certificate of conformity or a children's product certificate. What's changing is that the importer of record, the company that's responsible for bringing the product into the country, is now obligated to file that certificate electronically through the software that's already available. That's what's changing. So if you are a product seller or distributor or manufacturer of products that are subject to safety standards, nothing's changed with what you need to do, but the certificate now needs to be e-filed, and that's not an easy process. And we still, as I've mentioned, we do think that there's going to be continued enforcement for sure. Civil penalties likely are going to exist for late reporting, but the litigation docket right now at the CPSC does not have any significant cases on it that could lead to the types of criminal penalties that I just mentioned. Very quickly, we are at the end of the time. I do want to mention AI. I think what's really important about AI is that the CPSC is making this a priority, and it's making the use of AI a priority to detect hazards. Using things like predictive analytics, machine learning, modernized injury surveillance, all of that is leading to a heavy reliance on AI to help the CPSC do its job. The problem with that, as we all know, garbage in, garbage out. If you have false information out there through bots or on e-commerce platforms, you can certainly have false complaints being published. AI could result in the CPSC identifying hazards that really are not supported by the data. That doesn't mean that that's going to be a barrier to entry, though. They've recognized that risk, but they have nonetheless proceeded with making the use of AI a priority. And so you need to be prepared for that, and monitoring injuries and incident information, through social media, through e-commerce reviews, through customer reviews. All of that is important for you all to do, because you have to know the CPSC is doing that too. They just hired a, go ahead, Melissa.
I think let's say the CLE code one more time. We'll
Sure.
run this just I think it'll only be a couple of minutes over, and this will be posted online. So if you're like, wow, this is so great, I have to hear the last 5 minutes, you can find this online along with the slides in a few days. For those who need to jump off, thank you for listening. And the CPSC or the CLE code is CPSC 2025. Then we'll just run for just a couple of minutes more and take it from there. So thanks very much.
So just to close that out, thanks, Melissa. The CPSC has just hired in November 2 new senior staff members that have a significant AI focus. They hired a chief data officer, which I think is the first person to actually hold that position. And they hired a new deputy director for the Office of Risk Reduction, who comes from another government agency and was responsible for implementing AI at that agency to help the agency function. So a real clear signal that AI is going to be an important tool used by the CPSC moving forward. All right, Melissa, back to you.
Sure. And just for, it's important to remember that there are other agencies that regulate areas that are relevant or important, or separately regulate maybe products that the CPSC won't. So we mentioned the importance of marketing claims. Erin was just talking about how something that is talked about in a review, maybe something that the CPSC picks up on, maybe a claim, oh, well, I was hurt by this product, maybe important to monitor, not just because a false and misleading claim is in a review, but because an injury claim is in a review. So the FTC, of course, my other favorite agency, and I should also correct myself from earlier, the hearing at the Supreme Court, or the argument at the Supreme Court on Monday, is about the FTC's Humphreys executor case, not about the CPSC's Humphreys executor case, although obviously ultimately they're both relevant to the fired commissioners. But in any case, deceptive and unfair claims, if you make a deceptive claim about a product safety certification, about testing, or the like, with regards to your product, that may ultimately also raise issues under Section 5 of the FTC Act, which prohibits unfair and deceptive acts or practices. And in fact, there have been many, many such cases involving, misleading or false claims that a product is certified under a product safety standard or something like that. In addition, claims about environmental safety, environmental marketing, claims about where a product was made or the like are central right now, are major themes for the Federal Trade Commission, and may also be relevant from a product point of view. The other major agency when it comes to product safety is the FDA, really major statutes there are the Federal Food, Drug, and Cosmetic Act and the Food Safety Modernization Act. We hear a lot about food safety today, about cosmetics, drugs and pharmaceuticals, supplements, and that really falls within the purview not of the CPSC, but of the FDA. And sometimes there's an issue with products in these areas, even as to whether it will be regulated by one agency or another, the FDA or the CPSC. Is it the packaging or the product in the packaging? The FDA recall rules are a little bit different, but just as important as the CPSC's. Next slide. We hear a lot about some of the EPA, the Environmental Protection Agency's rules, the NHTSA rules for cars. FCC has rules. This is particularly when you're vetting a product that maybe is new to the market. These are all rules you need to think about. Energy efficiency as well. And so I just want to raise these to remind you that it's not just the CPSC that you need to worry about when you're making claims about products and product safety, or when you're bringing a product to market and you're assessing what types of rules you may need to evaluate as potentially applicable to your product. We do a lot of that here, and it's always sort of going down a list and making sure that your product is compliant with all of these rules that may be applicable. Next slide. The states, of course, have rules as well, and that's always fun going through that patchwork. Particularly important nowadays are issues like toxics in packaging and heavy metal limits. We all, I'm sure, have heard Prop 65, Prop 65, Prop 65 in California, which requires warnings about potential certain chemicals. There's a list that may cause cancer or reproductive toxicity if they exceed certain risk thresholds. And that law impacts a huge range of products, whether it's electronics, furniture, clothing, and the enforcement is not just by regulators, but private plaintiffs have gotten in the act as well. California also has a recycling law that can affect packaging. So it's important to be aware of these, as well as things like PFAS and other laws regarding chemical disclosures, flame retardants, and other topical type bans. So these state specific product laws are also increasing, whether it's something regulating sleep products, window coverings, or even just used products. When you've got these marketplaces now where used products may be sold, or so it's important to be aware of these when you're selling specific types of products, and stay abreast of new regulations and new lawsuits enforcing those regulations. Next slide. So, action plan. What are we worrying about for 2006? What are we doing in terms of compliance and making sure you're ready for what's coming next, whether it's regulatory action or lawsuits? Because of course the class action bar is active wherever they can find an opening. You really want to identify which of your products may fall into CPSC or state regulatory hot zones where lawsuits are coming out of, whether it's batteries or children's products, furniture, connected devices, or all of the above when it comes to certain types of activities. And then look at your incident escalation policies. Train the affected teams on when to call legal, when to call your product safety team. Update any of your design or testing or labeling, policies and rules for your, maybe start with your highest risk categories to stay up to date with evolving standards, and also, of course, strengthen your marketplace monitoring to keep up with the CPSC's priorities as well. Refresh your product playbook, and then keep watching where the CPSC rulemakings are going in your sort of hot areas, and consider sort of testing your systems with a mock scenario or a tabletop exercise. What does a CPSC ready program look like in practice? You need an owner for product safety and regulatory affairs who's regularly, hopefully, briefing senior leadership and the board, and then review what an incident escalation and your reporting procedures look like. Do you have clear decision trees for when to escalate and report? Do you have centralized intake and tracking of complaints, including your social media and review channels, now that we know that the CPSC is following those as well? Um, uh, so in terms of, can AI help you too? If it's helping the CPSC, if the CPSC is using it, you should be using it too. When it comes to testing and certification, map your product categories against what the CPSC is focusing on, whether it's batteries, children's products, etc., and then align those with voluntary standards. To the extent we don't have final rules yet, the voluntary standards are already following them, in addition to tracking where those CPSC rulemakings are going. Keep retesting those products to those standards then. And then maintain up-to-date CPC, documentation, all your product certifications, and tracking labels. And then just get ready for e-filing. Most companies hopefully are doing that already, but if you're not, we're of course happy to help you. So that's it. Any questions? If we haven't had a chance to answer them yet, send them in and we're happy to help out. Thanks very much for attending, and have a good rest of the week.